I will now instruct you on the law that applies to this case. I will give you a copy of these instructions to use in the jury room. You must decide what the facts are. It is up to all of you and you alone to decide what happened based only on the evidence that has been presented to you in this trial. You must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. Many people have assumptions and biases about or stereotypes of other people and may be unaware of them. You must not be biased in favor of or against any party, witness, attorney, defendant, or alleged victim because of his or her disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or socioeconomic status. You must follow the law as I explained it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions. Pay careful attention to all these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary everyday meanings. Some of these instructions may not apply, depending on your findings about the facts of the case. After you have decided what the facts are, follow the instructions that do apply to the facts as you find them. Do not use the internet or any other means of communication in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case, either on your own or as a group. Do not conduct any tests or experiments or visit the scene of the event involved in this case. If you happen to pass by the scene, do not stop or investigate. Your notes are for your own individual use to help you remember what happened during the trial. Keep in mind that your notes may be inaccurate or incomplete. If there is a disagreement about the testimony at trial, you may ask that the court's recording be played back to you. It is the record that must, or the recording that must guide your deliberations, not your notes. You must accept the court's recording as accurate. Please do not remove your notes from the jury room. At the end of the trial, your notes will be collected and destroyed. Because more than one defendant is on trial here, I am going to remind you which individuals are charged with which crimes. Defendant Alicia Santurio is charged with petty theft of a chicken. Defendant Alexandra Paul is charged with petty theft of a chicken. You must separately consider the evidence as it applies to each defendant. You must decide each charge for each defendant separately. If you cannot reach a verdict on both of the defendants or on the charge against either defendant, you must report your disagreement to the court, and you must return your verdict on any defendant or charge on which you have on charge which you have unanimously agreed. Unless I tell you otherwise, all instructions apply to each defendant. It is alleged that the crime here occurred on or about September 28, 2021. The people are not required to prove that the crime took place exactly on that day, but only that it happened reasonably close to that day. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because she has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond reasonable doubt, she is entitled to an acquittal, and you must find her not guilty. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they help you to understand the witnesses' answers. Do not assume that something is true just because one of the attorneys asked a question that suggested it was true. During the trial, the attorneys may have objected to questions or moved to strike answers given by the witnesses. I ruled on the objections according to the law. If I sustain an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I ordered testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything you saw or heard when the court was not in session, even if it was done or said by one of the parties or witnesses. The court has made a record of everything that was said during the trial through electronic recording. If you decide that it is necessary, you may ask that the court recording be played back to you. You must accept the recording as accurate. Facts may be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. For example, if a witness testifies that he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of water, that testimony is circumstantial evidence because it may support a conclusion that it was raining outside. Both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state and acts necessary to a conviction, and neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact in issue has been proved based on all the evidence. Before you may rely on circumstantial evidence to conclude a fact necessary to find the defendant guilty, has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to find the defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence and another to guilt, you must accept the one that points to innocence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. The people must prove not only that a defendant did the act charged, but also that he or she acted with a particular intent. The instruction for each crime and allegation explains the intent required. An intent may be proved by circumstantial evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find a defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to conclude that a defendant had the required intent, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that a defendant had the required intent. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions supports a finding that the defendant did have the required intent, and another reasonable conclusion supports a finding that a defendant did not, you must conclude that the required intent was not proved by the circumstantial evidence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. You alone must judge the credibility or believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudice you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are: how well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? Did other evidence prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful? What is the witness' character for truthfulness? Has the witness engaged in other conduct that reflects on his or her believability? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. The crime charge in this case required proof of the union or joint operation of act and wrongful intent. For you to find a person guilty of the crime of petty theft, as charged in count 1, that person must not only intentionally commit the prohibited act, but must do so with a specific intent. The act and specific intent required are explained in the instruction for that crime. The specific intent required for the crime of petty theft is the intent to deprive the owner of the property in question permanently, or to remove it from the owner's possession for so extended a period of time that the owner would be deprived of a major portion of the value or enjoyment of the property. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. The testimony of only one witness can prove any fact. Before you conclude that the testimony of one witness proves a fact, you should carefully review all the evidence. If you determine there is a conflict in the evidence, you must decide what evidence, if any, to believe. Do not simply count the number of witnesses who agree or disagree on a point and accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of any witness without a reason or because of prejudice or desire to favor one side or the other. What is important is whether the testimony or any other evidence convinces you, not just the number of witnesses who testify about a certain point. During the trial, certain evidence was admitted for a limited purpose. You may consider that evidence only for that purpose and for no other. A witness was allowed to testify as an expert to give you an opinion. You must consider the opinion, but you are not required to accept it as true or accurate. The meaning and importance of any opinion are for you to decide. In evaluating the believability of an expert witness, follow the instructions about the believability of witnesses generally. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. An expert witness may be asked a hypothetical question. A hypothetical question asks the witness to assume certain facts are true and to give you an opinion based on the assumed facts. It is up to you to decide whether an assumed fact has been proved. If you conclude that an assumed fact is not true, consider the effect of the expert's reliance on that fact in evaluating the expert's opinion. Witnesses who were not testifying as experts gave their opinions during the trial. You may, but are not required to accept those opinions as true or accurate. You may give the opinions whatever weight you think appropriate. Consider the extent of the witness's opportunity to perceive the matters on which his or her opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the witness relied in forming the opinion. You must decide whether information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. You have heard character testimony that defendant Alexandra Paul is an honest person. Evidence of a defendant's character for these traits can by itself create a reasonable doubt. However, evidence of a defendant's good character may be countered by evidence of her bad character for the same trait. You must decide the meaning and importance of the character evidence. You may take character evidence into consideration along with all the other evidence in deciding whether the people have proved that a defendant is guilty beyond a reasonable doubt. Dr. Sherston Rosenberg testified that in reaching her conclusions as an expert witness, she considered statements made by third parties. You may consider those statements only to evaluate the expert's opinion. Do not consider those statements as proof that the information contained in the statements is true. The people are not required to prove that a defendant had a motive to commit any of the crimes charged. In reaching your verdict, you may, however, consider whether a defendant had a motive. Having a motive may be a factor tending to show that a defendant is guilty. Not having a motive may be a factor tending to show a defendant is not guilty. A person may be guilty of a crime in two ways. One, he or she may have directly committed the crime. I will call that person the perpetrator. Two, he or she may have aided and abetted a perpetrator who directly committed the crime. a person is guilty of a crime whether he or she committed it personally or aided and abetted the perpetrator. To prove that the defendant is guilty of a crime based on aiding and abetting that crime, the people must prove that, 1, the perpetrator committed the crime, 2, the defendant knew that the perpetrator intended to commit the crime, 3, before or during the commission of the crime, the defendant intended to aid and abet the perpetrator in committing the crime, and 4, the defendant's words or conduct did in fact aid and abet the perpetrator's commission of the crime. Someone aids and abets a crime if he or she knows of the perpetrator's unlawful purpose and he or she specifically intends to and does in fact aid, facilitate, promote, encourage, or instigate the perpetrator's commission of that crime. If all these requirements are proved, the defendant does not need to actually have been present when the crime was committed to be guilty as an aider and abetter. If you conclude that the defendant was present at the scene of the crime or failed to prevent the crime, you may consider that fact in determining whether the defendant was an aider and abetter. However, the fact that a person is present at the scene of a crime or fails to prevent the crime does not by itself make him or her an aider and abetter. The defendants are charged in count 1 with petty theft by larceny. To prove that a defendant is guilty of this crime, the people must prove that 1, a defendant took possession of property owned by someone else. 2, a defendant took the property without the owner's or owner's agent's consent. 3, when a defendant took the property, she intended to deprive the owner of it permanently or to remove it from the owner's possession for so extended a period of time that the owner would be deprived of a major portion of the value or enjoyment of that property. And 4, a defendant moved the property even a small distance and kept it for any period of time, however brief. An agent is someone to whom the owner has given complete or partial authority and control over the owner's property. For petty theft, the property taken can be of any value, no matter how slight. A witness gave his opinion of the value of the property he owned. In considering the opinion, you may, but are not required, to accept it as true or accurate. Consider the reasons the witness gave for any opinion, the facts or information on which he relied in forming that opinion, and whether the information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find unbelievable or unreasonable. You may give the opinion whatever weight, if any, you believe it deserves. The crime of petty theft requires the defendant act with a specific intent, as explained above. A defendant is not guilty of petty theft if she made an honest or good faith mistake about the law, if that mistake shows that she did not have the specific intent required for the petty theft. If you have a reasonable doubt about whether a defendant had the specific intent required for petty theft, you must find her not guilty of that offense. Do not take anything I said or did during the trial as an indication of what I think about the evidence, the witnesses, or what your verdict should be. It is not my role to tell you what your verdict should be. You are the sole judges of the evidence and believability of the witnesses. It is up to you and you alone to decide the issues in this case. You may disregard any or all of my comments about the evidence or give them whatever weight you believe is appropriate. All right. There'll be an additional one last piece of instruction, but I will give that to you after the attorneys have finished their closing arguments. At this point, the court will turn to the people to present their closing arguments. Mr. Colby.
Thank you, Your Honor. These defendants took property that did not belong to them, and it was simply an activist stunt. Now, this was simply intended to disrupt the chicken company. In California, chickens are property, and it's clear that the defendants have a very deeply held belief that that should be different. As Instruction 200 tells you, you must follow the law, even if you disagree with it. It's not the forum to try to change the law. And that's what's happening here. This is an activist stunt that the defendants did. They're free to disagree with that, but you can't take property. They're free to disagree with the fact that chickens are property. But you can't take property from another just because you disagree with it. Now, the chicken business may not be a pleasant business. How chickens are processed into various different products is something that most people have no experience with. Some people do, but the fact is it may not be pleasant, and people are free to disagree with that. But again, that's not what happened here. This is not a disagreement that is perfectly fine. This is an activist stunt. Out to the Foster Farms plant in Livingston, this group, Direct Action Everywhere, coordinated this protest. It involved a U-Haul truck blocking the ingress and egress of Foster Farms, blocking the trucks coming in. And these two defendants come up in a vehicle in a coordinated fashion, jump out of the vehicle, sprint towards this truck, carrying about 5,000 chickens. They run up to it, open the one accessible hatch in a millisecond, grab the first two chickens that are there, as the video shows. And it's clear that this was a plan. It was admitted it was a plan. So if you look at Exhibit 101, the video, take a look at Miss Paul. Look at what's in her backpack. You see two handles sticking out, looking like the handles of cutters?
Your Honor,
This was a plan.
objection, this is not evidence that's been introduced.
Well, okay, it's a printout of the video. You want
Exhibit
to
101.
go and have you shown defense counsel?
I have not seen any of these
Okay,
images.
go ahead.
I also have heard no commentary about anything sticking out from anything. I don't know what the closing argument is referring to, but I'd like to see the images
Yeah, go ahead.
before.
Just present it to defense
Fine.
counsel.
Thank you. Here, I'm also going to object if we can approach.
these are still photographs of the video that have been omitted. These in themselves are not the evidence. It's the video that has been omitted, ladies and gentlemen, is the evidence, but the people may discuss the stills. The objection regarding the nature of the two handles sticking out is sustained.
So ladies and gentlemen, as I was saying, stills from the video, exhibit 101, you can see two handles sticking out of Ms. Paul's backpack. Grab the first two chickens that are there, as the video shows. And it's clear that this was a plan. It was admitted it was a plan. So if you look at exhibit 101, the video, take a look at Ms. Paul. Look at what's in her backpack. You see two handles sticking out, looking like the handles to cutters?
Your Honor,
This was a plan.
objection, this is not evidence that's been introduced.
Well, okay, it's a printout of the video. You want
Exhibit
to go
101.
ahead, have you shown defense counsel?
I've not seen any of these images.
Okay, go ahead.
I also heard no commentary about anything sticking out from anything. I don't know what the closing argument is referring to, but I'd like to see the images.
Yeah, go ahead.
Before-
And just present it to
Go
defense
ahead.
counsel for me.
Thank you. Mayor, I'm also going to object to the approach.
Did in fact aid and abet the perpetrator's commission of the crime, they can be guilty. So why bring that up? Well, they're obviously acting with a plan here. They're taking both the chickens. So if one of you is thinking, well, only one of the chickens died, the other one survived, and by Ms. Paul's testimony, healthy. Well, no, this was a plan of them to take the chickens. And they are aiding and abetting each other. That's clear by the evidence. So that's not, by the way, we'll explain in a minute why the health of the chickens is not going to be a defense in this case for them. But even if it were, so when we talk about the elements of the crime, Instruction 1800, and again, this is the law you're bound to follow, talks about the elements to follow. Number one, the defendant took possession of property owned by somebody else. Number two, the defendant took the property without the owner or owner's agent's consent. Number three, when the defendant took the property, they intended to deprive the owner of it permanently or to remove it from the owner or owner's agent's possession for such an extended period of time that the owner would be deprived of a major portion of the value of enjoyment. So they took it without intending to get it back. The defendant moved the property even a small distance and kept it for any period of time, however brief. Now, of those elements, there's no question that they took property belonging to Foster Farms. It was on a Foster Farms truck, bound for the Foster Farms plan. There's no question that they took the property without the consent. They didn't even ask the truck driver if they could take it. They didn't ask Foster Farms, okay, can we look for 6 chickens? They just took it. So, number 4, moving the property, there's no question there. It's not an issue. So they're going to, throughout the trial, you've heard testimonies that tried to call into question their intent. One of the things that was mentioned in opening statement is that the question is why. Why did they take the chickens? It's not as simple as that. Now, this is a simple case in terms of the facts, but the broad question of why, everything that's going through somebody's head, is a question of motive. Motive, instruction 370. The people are not required to prove that the defendant had a motive to commit the crime charged. In reaching your verdict, you may, however, consider whether the defendant had a motive. Having a motive may be a factor tending to show the defendant is guilty. Not having a motive may be a factor tending to show the defendant is not guilty. Now, the motive in this case was the political stunt. The motive was to, while Foster Farms was barricaded, jump out and take these 2 chickens, claiming to rescue 2 chickens out of the back of a truck, but it was clearly for a political stunt. That tends to show they're guilty. Now, the question of why is not all-encompassing when we talk about specific intent. Specific intent, instruction 1800, is not just why. Here's what it is. When the defendant took the property, she intended to deprive the owner of it permanently or for that extended period of time. Now, we know that they did intend to do just that. Neither of the chickens were returned to Foster Farms. Matter of fact, one of them, apparently healthy today, according to the testimony. And when Ms. Paul was asked, would you return the chicken? No. So that's obvious, that's their intent. It's very important to distinguish intent from motive. This political statement or this activist statement of why I want to do it, because I want the law changed, is not a defense. If they have this intent, whatever their motive may be, if they have this intent to take the chicken from Foster Farms and not return it, they're guilty.
Objection, that's in the statement of the law.
Overruled, the jury can, as indicated, read the instructions of the law as the court gave you. If the attorney's comments on the law conflict with the law, then you may follow the court's instruction.
Now, they have that intent, they're guilty. Their motives, even if you believe with their motives trying to change the industry, that's not what this courtroom is about. The question is one of specific intent. So the next issue that I'm sure you'll hear about is value. It was claimed throughout the trial these chickens have no value. Well, that's not really consistent with the facts and the evidence. The facts that there's this protest that sets up by these activists and blocks the ingress and egress, and then the defendants come up behind that in a coordinated effort, running up and taking these 2 chickens out of the back of the truck, shows you that there was value here. By that very nature, they wouldn't have been trying to take chickens out of the back of Foster Farms truck if they didn't think that Foster Farms had value in them such that they wanted to keep them. And value is not really an issue anyway. You've heard Foster Farms say that we use all the birds. Now, you may disagree with that. You may disagree with that, and that's fair. You're bound to follow law, and what the law says is that if it has value, then it can be any value, however slight. It's somewhat disingenuous to say that chicken you're stealing out of the hands of somebody else, out of a truck of somebody else, doesn't have any value. That's a bit
Your Honor, I'm going to
disingenuous.
object to the comment disingenuous. That's unfair denigration of defense counsel and defense.
Actually, it's a comment to the defendant's testimony. Your Honor.
Objection overruled.
So you heard the defendant say that they were taking it out of the hands of Foster Farms. They disagree with Foster Farms. That's fine. You can disagree with Foster Farms, but you can't take something just because you disagree with it. And to say that it has no value from the testimony you heard is disingenuous with the fact they did the acts. Nobody's disputing they did the acts here. So what's the next question? Mistake of law. You heard the court read that instruction 3411, mistake of law. Now, what evidence did they talk about in trying to talk about the mistake of law throughout their witnesses? They said, oh, we have this letter from 2018, 3 years before this happened, that says we might have a defense to this. Well, that letter was written to Direct Action Everywhere. That was noted in the testimony. That shows you how self-serving that letter was. It was self-serving to try to justify this activist stunt. Mistake of law. The crime of petty theft requires the defendant act with a specific intent, as explained above. A defendant is not guilty of petty theft if she makes an honest or good faith mistake about the law, if that mistake shows she did not have the specific intent required for petty theft. So, the first question, was there a mistake there? Did they make a mistake? And the answer to that is based on the evidence, no. They did what was against the law, knowing it was against the law. There was no mistake about that. And it wasn't because they mistakenly believed something about the law that would negate their intent. It's because they wanted to do it. And that goes to whether or not that's an honest or good faith statement about whether or not there's a mistake of law. Did they honestly believe that something that would make them not have the intent to take these chickens and deprive foster farms of the chickens? No. Did they have the specific intent to take the chickens? And did they intend to deprive foster farms of the chickens? Absolutely, yes. Everything regarding that letter is purely self-serving. The complaints, they said, well, there have been complaints against these companies written on the letterhead of direct action everywhere. Self-serving. Again, part of this activist stunt. Nothing about that negates the fact they had the specific intent to take the chickens and deprive foster farms. They did so because they wanted to change things and disrupt the farming industry. That's what the evidence shows you. That's why they did this. It was a disruptive act. And now they've had their day in court, and the evidence has shown
Objection, this is improperly commenting on the defendant's exercise of their right to a trial.
Objection overruled.
now they've had their day in court, and the evidence has shown that that's exactly what this was. Now, you heard a lot of talk about the health of chickens, and this was used as a platform for that. But what did you hear from Rosenberg, Dr. Rosenberg, who testified? She did tell you about testifying before the legislature on the legislative process. That's the appropriate forum to try to change the law, not in a court. You don't go stealing something of somebody else just because you don't like that other person or that other company or how they do business. That's not the law. This court is not the forum to argue those beliefs. And the law you swore to follow, Instruction 200, says these defendants are guilty of this crime. They took the chickens. They intended to take them from foster farms and not give them back. They did so without a legal basis. And they took the property of another because they wanted to, regardless of what the law says, knowing taking was against the law. This is no mistake of law. There's no thinking, oh, well, I had a legal right to do this. They said that, oh, I thought I did. But does that square with all the evidence of this coordinated protest? Does that square with all that? Well, no, it really doesn't. It doesn't make sense. Now, in reviewing the evidence, you're to accept only reasonable conclusions. You're to reject any that are unreasonable. So think about that. We're here because this is an activist stunt. Defendants took these 2 chickens off the back of this truck with 5,000 chickens. One defendant even said she worked with a chicken rescue that would rescue 500 chickens at a time on occasion. This isn't about when you go take 2 chickens in a split second on the back of a truck. It's not about rescuing chickens. It's about disagreeing with the way the farm is doing their business. And it doesn't matter if it's a commercial farming industry or a person or another company. The law says no. The law says if you disagree with somebody, you can't just take their property. And they knew it was illegal. They did it anyways to make a statement. Instructions make it very clear that what they did violates the law. So, ladies and gentlemen, when you review all the evidence about this coordinated activist action against foster farms and the stealing of the 2 chickens, absconding with them, taking off in the car, and everybody who has testified with it, including Dr. Rosenberg, who testifies in court 8 times, 5 of which for direct action everywhere, 3 of which, interestingly enough, I started to ask her about that. You remember that? I said, who did you testify for in those other 3? Well, the answer was hesitant. And we finally got to the answer of, well, was it for a farming interest? And the answer was no. Couldn't get to the answer of who it was, but that's what we got to. So what does that mean? This is all part of an activist. So that's what this is. They took the chickens. They shouldn't have. And the law says you have to find them guilty based on these facts. Instruction 200, you must follow the law as read to you, whether you agree with it or disagree with it. It's not about beliefs. This is a great country we live in for a few reasons, one of which is you can believe whatever you want to believe. You can go in the deepest, darkest recesses of the internet and find all sorts of beliefs out there. The fact is, you're not punished for what you believe. It's not about what you believe, it's about what you do and how that affects others. Others includes businesses. It includes people. And the state of California says a chicken is property. You're not allowed to take property of another, intending to take the property and deprive somebody of it, regardless of your beliefs. And the mistake of law defense here, it does not make them not guilty. They specifically intended to take the chickens. And they did so intending to deprive Foster Farms. Nothing about what they said about their claimed mistake of law changes that. Hold them accountable for what they've done. And in your verdicts, find them responsible. We've been given 4 verdict forms back there. 2 for each defendant. Each defendant will have 2. One says guilty, one says not guilty for each defendant. So the evidence has shown you that the only reasonable conclusion you can draw on the answer here is that the defendants are guilty, and the guilty form should be signed for both defendants. Thank you very much.
All right, thank you.
It wasn't a stunt. Alexandra Paul and Alicia Santurio, they knew Foster Farms treated their animals with abject cruelty, well beyond any standard that would be acceptable, not just by people who deeply care about animals, but by anyone. And they knew that was particularly the case inside of that Livingston slaughterhouse. They also knew that in those transport trucks, balance of probabilities, they are going to find sick and suffering birds as a result of the systemic, constant neglect that Foster Farms puts towards these birds. And it was no surprise when they opened that cage to that transport truck that they found sick and in distress birds. So what did they do? They applied what they knew, the facts ahead of them, to legal advice that they were given that is highly conditional. And the conditions were met. And they believed in their heart of hearts that they were permitted to rescue those birds. Because they did what they thought was the right thing to do, the necessary thing to do, and most importantly, what they believed under those conditions was the lawful thing to do. And that's why they're not guilty. Now, this case is really focusing on 2 questions. The first question is the why, and that relates to the specific intent. And when you resolve the why question, the result is going to compel you to find them not guilty. And I'm going to spend my closing talking to you about the why. But the second question is really going to be value, and my colleague, Mr. Hsiung, is going to talk about that. But briefly on the value question, the prosecution has the burden of proof beyond reasonable doubt that these 2 birds had some positive value. And what did the credible evidence in this trial actually show you? These birds meant nothing to Foster Farms. They were treated like nothing. They were treated like trash. If anything, they were a liability. They were sick. They were a liability to other birds and ultimately Foster Farms' bottom line, which is all about money. But they were a liability to consumers and their pets. And they shouldn't even been on that truck because of their condition. They had no value. If we want to take stock of the ledger, it's red. It's negative. It's no value. Well, my colleague will spend some time talking about that. What I want to focus on is the why. And I think we can start with the jury instructions and figure out why the question of why fits in. And it's that highlighted part on what the defendant intended. That's where you're allowed to examine this why question. That's where it starts becoming relevant. But it's just not this component, it's another instruction. where it says the prosecution not only needs to prove beyond a reasonable doubt the act, but also the requisite mental state, which is that specific intent that Mr. Colby first started talking about. And in this case, generally the act and the mental state are equally important. But I think in this case, the mental state is more important because, as Mr. Little said, this ain't a whodunit. This is a why done it. It's not in dispute that they rescued those chickens. It's the question of why. And that's why we had such significant discussions during jury selection with fellow potential jurors. Is it simply enough that they did it on video? And it's not. It goes to the intent, but the prosecution has the burden of proof beyond a reasonable doubt, because we never have any burden in this case. And then finally, the most important instruction as it relates to the why question is mistake of law. And you will have that instruction readily available to you when you go back and deliberate, but there are some things I really want to highlight about what mistake of law is and what mistake of law isn't. And it's an honest or good faith mistake. The focus is on their mental state, what's in their mind. Honest or good faith. What mistake of law isn't, it's not whether you agree with it. I think it's a fair personal opinion to have. I just don't like the fact that they can say an attorney told them they could do it and they're not guilty. I get it. It's a fine opinion to have. But as Mr. Colby stressed, the reason that you are jurors in this case, that you were selected, is because you could swear an oath saying you will follow the law as described to you, as given by the court. And the law here says that it can be a defense when it negates the appropriate mental state. So whether you agree with that or not, that is not the standard. It goes back to their mental state. What did they earnestly believe? And it's not even if their belief is reasonable. It's their subjective belief. So, you may think that Ms. Paul and Ms. Santurio have a different worldview. They view the world differently. And what's reasonable to them may not be reasonable to you. And that's okay. I think we live in a country where a lot of people have these different standings. But again, it's what they subjectively believed. And of course, they don't have to be right. This trial is not whether their belief was correct or not, hence the mistake part of the mistake of law. Because it all goes back to what they believed. So let's sort of take stock of what the facts in this case show. Because the facts in this case, it goes to what they knew before they committed that rescue, and how they committed that rescue, and how it aligned neatly, and perfectly, and adequately, correctly, with the legal advice that they understood. So we know the evidence has shown that foster farms, they don't take care of their birds under really any standard. Ms. Santurio told you, it doesn't matter what facility we investigate, it doesn't matter when, we find the same systemic cruelty. We find birds that are just dead, being eaten by maggots, birds that are stuck in feeders, things that would just simply shock their conscience. And the prosecution elicited some questions about some certification about the American Humane Association. Interestingly enough, they presented no evidence what that actually means. They didn't talk to any of their witnesses from foster farms about that. The only evidence that you actually have about the weight of that is that it's a scam. And think about it. You pay someone to give you a nice little rubber stamp of certification, and they tell you, hey, we're going to come check on you tomorrow. A little wink and a nod, you're going to be ready. And surprisingly, they get the certification. But they don't get advance notice when investigators come. And they find consistent, repeated violations and problems. And interestingly enough, Ms. Santurio told you, I actually looked at some of the guidelines that the American Humane Association has. And one of them is if a bird should be able to walk more than 5 feet. And what that means show you here. The birds in foster farms care didn't meet that elevated standard, and frankly, didn't even meet any lower standard. And I think what they knew about the care foster farms gives their birds is relevant as to why they felt compelled to rescue sick and suffering birds. because they also knew what happens inside that slaughterhouse. You heard testimony, there was an undercover investigation, and they viewed videos that confirmed what they already knew. Inside that slaughterhouse, live birds are being picked up, they are being slammed on the ground, they are being thrown in barrels, they're having other birds thrown on top of them, suffocating them, and on and on and on. And what is the reasonable conclusion? The reasonable conclusion is if you have a sick and suffering bird and it needs help, it ain't gonna find that help inside that slaughterhouse. In fact, it's gonna find more exceptionally bad animal cruelty. So rescuing animals was not their first recourse. You heard that Ms. Santurio did vigils outside of foster farms. Nothing happened. You heard they wrote letters to authorities. Nothing happened. And I think one of the jurors actually asked, well, did you try to talk to foster farms? And remember Ms. Paul's testimony? Yeah, we did. In fact, Ms. Santurio went there to try to talk to them about these conditions. And what was the constant response for all these actions? Indifference and inaction. And what would that make someone think? These birds go in, no one's going to care. Their suffering increases. And I want to be really clear here. This rescue is not just some fundamental moral objection to slaughtering birds or any animals for food. Their focus on foster farms is not just because there's some arbitrary slaughterhouse. It's because foster farms was exceptionally bad. And they put themselves out as holding themselves to a higher standard. And it was the exceptionally bad conditions inside foster farms that caused them to focus on foster farms. But it wasn't the only thing they did, is writing letters to authorities and trying to talk to foster farms. They got legal advice from 2018. The prosecution wants to reference this as some sort of self-serving thing. And that argument would hold some weight if it was, hey, we're going to go do this action tomorrow. Can you just give me a little legal opinion to cover my butt? But the legal advice they got was in 2018, well before any demonstrations, any information about foster farms.
Objection, improper argument.
This is a proper response.
May counsel approach.
Argument.